Hello, and thank you for joining us. This is No Soundbites Allowed, and I am your host, Michael Voss, Dragon of the Southern Tier. I'm happy to be here with you today. This is early in the morning of November 17th at approximately 2 a.m., and we're speaking with you on a very important issue. We're talking about the Kyle Rittenhouse trial in Kenosha and some information that is breaking as we speak and will be obviously one of the most talked about items tomorrow. And we want to speak with you because this has an impact on the Second Amendment. This has an impact on self-defense. This has an impact on every American going forward. The consequences are extreme. So before we get to that, though, we do want to also mention, if this is the first time that you are seeing our channel, we welcome you and we thank you for joining us. We want you to know that we do long-form political commentary. And every Sunday at 2:30 p.m. Eastern Standard Time, we do a live stream with you. We reach out on YouTube, Facebook, Twitter, DLive, essentially all of the social media that the internet overlords will allow. And we do that because we want to celebrate your right to free speech, your First Amendment right. And this is a right anywhere in the world. Regardless of whether your government agrees, regardless of whether the internet overlords agree, you have a right to speech that is inalienable, undeniable. And we want you to celebrate that every Sunday at 2:30 p.m. Eastern Standard Time with us in our live stream to speak about what you think are the important issues affecting all of us across the globe. We hope to see you very soon. With that said, let's address what we've heard. In the last 24 hours, we have become aware of information that directly and dramatically affects the Kyle Rittenhouse case. To be very brief about this, the Kyle Rittenhouse case goes back to 2020. The summer of 2020, when we saw throughout this nation, BLM and Antifa and other far-left radical groups like the Progressive Leaders of Tomorrow, otherwise known as PLOT, were going around the country and creating riots, wholesale burning down of cities, destruction of property, and the death of innocents like David Dorn, Jessica Dottie Whitaker, the children in Atlanta and in Seattle and in Portland. And during that time, a gentleman named Jacob Blake, a criminal who was wanted for the sexual assault against a woman, was had the police called on him. He resisted arrest with a weapon, as he has admitted himself on the national news media. He also went to get additional weapons and was shot several times. And because of that, there was a riot. And this was not uncommon throughout all of the second half of 2020 across this nation. One of those riots, or one of the riots that were occurring, were in Kenosha. And Kyle Rittenhouse was involved. Kyle Rittenhouse, as you may be aware, was then placed on trial after he voluntarily gave himself up to the police. Whether you agree with Kyle Rittenhouse or not in terms of his innocence is not what we're speaking about at this moment. The trial is ongoing. The evidence has been presented. We do believe on this channel, and I believe personally, that Kyle Rittenhouse is innocent of the charges that have been brought by the prosecution. There is evidence overwhelmingly that he committed self-defense. He protected his life in extreme circumstances. You may or may not agree with that, and that is your right. But what is separate of that, and what is important, is what this case means. The reason that this case exists, as we have spoken about before, isn't because of Kyle Rittenhouse. This is not about the innocence or guilt of Kyle Rittenhouse, or whether or not he had the right to defend himself. This is in reference to, and this case is about, politics. That is our opinion. It is about politics. It is about the Ninth Circuit Court deciding that you do not have a right to defend yourself with a firearm outside of your home. And in some cases, depending on the red flag laws, you do not have a right to defend yourself within your home. This is the disarmament of the American people, in our opinion. We believe that the Rittenhouse trial has a direct impact on the Second Amendment, as we have heard from Beto O'Rourke, who is now seeking the governorship in Texas after having failed the Senate race as well as a presidential run. He has stated directly in 2019 that he will take your firearms, all Americans. We have heard from CNN Joe Biden as he spoke at a town hall nationally televised when he told America he wants to take your 9mm handguns and any firearm, that is handguns, rifles, any firearm that has the capability of being able to fire more than 7 rounds. This is a problem for America. This is taking away your Second Amendment right, something that we have heard from Democrats for decades now, and most recently, within the last 5 to 7 years, they have emphasized and directly stated, you do not have the right to have a firearm, that the government is the only one who has the right to be armed, which is wrong. That is not what the Constitution says, and they are counting on the fact that you will not read the Second Amendment to understand what your rights are. That brings us to the Rittenhouse trial. And in the Rittenhouse trial, as we have been discussing with you on this channel, Mr. Rittenhouse is an example of how and why they want to take away your rights. We have seen that the prosecution has come out and directly stated that they would prefer Kyle Rittenhouse to be beaten up, in the words of Prosecutor Kraus, one of the ADAs for Kenosha. And I would only refer you to the history of the Rodney King riots and looking at what happened to individuals when they were beaten up. Look at David Dorn as an example of the violence of being beaten up. The individuals in Dallas, in Austin, in Boulder that were just beaten up. Self-defense is not limited to your political preference. That is a fact. Nor is it defined by the color of your skin, as we hear many people try to say at this time. Throughout the Kyle Rittenhouse trial, and that's something that you may have followed, and we do recommend that you follow it based on Ricada law. He has been following this since the beginning with 6 to 10 additional attorneys on the channel going over the actual law, looking at the objections both for the prosecution and for the defense, explaining what is going on in the trial as it is playing live, except when the internet overlords shut it down, as they did 2 days ago. This trial has shown a great deal of evidence. The problem is, not all the evidence has been provided. In fact, we have seen now that the prosecution, besides violating the Fifth Amendment rights of Kyle Rittenhouse, which is an immediate issue, a constitutional violation, not just state law, not just local law, not even federal law. It is a constitutional violation of the rights of the defendant. This is a violation of your rights. Not only did the prosecution violate the Fifth Amendment rights of the defendant, they also went forth and violate the court as well, introducing evidence that was explicitly and absolutely prevented from being in the trial. Information and evidence that was biased and therefore was rejected from coming into the court. And then they went even further, being reprimanded by the judge during the closing statements for trying to introduce further information that they knew could not be discussed with the jury, that was not presented in the trial, that was unsubstantiated guesses. meant only to prejudice the jury and perhaps to also try and get a mistrial. But the information doesn't stop there, as we have learned in the last 24 hours. And I want to get right to that at this time, and I thank you for your patience in us trying to make sure we have been providing a clear understanding of the case and the problems in this case to date. And one of the biggest things that came out today, which was not made known to the jury, is this information. There is an individual in videos that are central to several of the charges in this case. An individual who has been identified as Jump Kick Man, an individual who assaulted Kyle Rittenhouse as he lay on the ground, kicked him in the face with a boot. This individual, who is central to what was going on that night, what was in the mind of the mob that was attacking Kyle Rittenhouse, and we have now found out from WISN, channel 1130, Dan O'Donnell has presented the information that there is the identity of this Jump Kick Man, which we have been told by the prosecution was unknown. It was impossible to find this individual as a witness that could be presented both for the prosecution and also called by the defense to explain what happened that night. That the prosecution lied. They lied to the public. They lied to the court. They lied to the jury in this trial. And we would have to imagine the only reason that the prosecution would lie about a material witness and someone who has committed a crime, yes, attacking Kyle Rittenhouse while he was laying on the ground, was a crime separate of anything else that happened that night. This individual who allegedly committed that crime has been identified and in fact was always known to the prosecution. Jump Kick Man has been identified as a 40-year-old black male from Kenosha with an extensive criminal record who and was at the time of the Kenosha riots was on probation following a conviction for domestic violence and battery. Something that he faced 9 months of jail for. In fact, this individual has had a history of crimes and convictions and probation. They have denied justice, which is what our jury system is about. The legal system in America may not be the best in the world. It may have many problems. And we have heard from the far left over and over again that that is the case. And they use that as a justification to commit riots and to destruction of property and attempted arson. But let's be very, very clear. This is beyond the pale. No matter what issues you may have with the justice system, this is above and beyond that case. When the prosecution is willfully denying the ability, refusing to present someone who would either clear or damn a defendant, and they choose not to do so as to prejudice the jury, and to get a predetermined political outcome, that is insane. That cannot be allowed. And again, this information has only just been learned, that the prosecution has had this evidence since before the start of the trial and denied to admit this, to make the defense know of this, and to do anything about this. I don't know what the words are for it. It troubles us so deeply. It shows a bias and a corruption in Kenosha that is to the core of the justice system. And if for no other reason, aside from the Fifth Amendment violations, which are reason for mistrial with prejudice, in other words, meaning that Kyle would be let free, all charges would be dropped, and he could never again be tried for these charges, while the Fifth Amendment violation is enough to cause that to happen, the additional violations by the prosecution throughout this case and the lies that they presented were enough to cause a mistrial with prejudice. The fact that they have hidden a witness that they knew of that could materially impact this case, there should be charges against the prosecutor Binger and prosecutor Kraus, because this is unacceptable. They have violated the law, the will, the words, every aspect of the justice system has been broken in this case for politics. Because this is a high-profile case, the nation is paying attention, and they know this, and they believe their careers are on the line. And for the benefit of money, their careers, their fame that they wish to have, and for the progressive democratic politics that they wish to support, to disarm American citizens based on the outcome of this trial, they decided to corrupt the system. As we have seen earlier today, as it was being reported, that there are protesters who are standing directly outside of the courtroom in Kenosha, that they are demanding a criminal charge, trying to coerce the jury to come up with a charge that they want, which benefits their political ideology, an ideology that says that this is about racism, which is ridiculous on its face. Kyle Rittenhouse, yes, he is white. So are all of the victims, all the individuals that were shot. Each and every one of the individuals who have prior criminal records, severe prior criminal records, domestic violence, the abuse of minors, sexual abuse of minors, criminal possession of guns and drunken charges of drunkenness, Revolutionary Communist Party members, to which Mr. Gage Grosskreutz, one of the witnesses and one of the individuals shot by Kyle Rittenhouse, is affiliated with, as he said in the trial, and whom he has had speeches with, as he stated in the trial. These are the individuals who are seeking to intimidate the jury. Yet again, another reason why this is unacceptable, why there should be a mistrial, that they are trying to use intimidation tactics, the threat of violence, to try and cause the jury to change their vote. And it is working. As we have learned earlier today, while the jury is in deliberations, we have heard that 10 out of 12 jury members already have a decision. There are two individuals, two jurors, who are not willing to put a decision forward, or rather I should say a decision that opposes the rest of the jury. And the reason for their denial is they are afraid of the violence of groups of individuals like the Revolutionary Communist Party. That the intimidation, the threat of violence, the coercion that is coming from the Revolutionary Communist Party, the far left, is effectively changing the direction of a trial. If this information is exactly correct, and we have no reason to believe it is not, it means that 12 jurors already have come down with a decision. And by implication, it appears that they recognize the innocence of Kyle Rittenhouse. And rather than siding with that decision, their fear of the far left, of the riots that we have seen in 2020, their fear of their families and themselves being attacked by social media and the news media, is enough for them to condemn an innocent person to jail. That is a travesty of justice, on top of the other additional travesties of justice we have just described to you. And then it gets even worse, because we want you to be aware that there is even more information that has come to light today, or rather late in the evening of November 16th. And that information is that the prosecutor Binger and Prosecutor Kraus in Kenosha have violated the Brady laws, that they've had a Brady violation. And I'm going to explain what that means in just one second, but it's as simple as this. There is a central video, which you may have seen in the ending rebuttal of the prosecutors, introducing into evidence a video that if you look on this screen right now, the video here at the top, a low quality video provided by the FBI, was introduced and given to the defense. Below, you see a high quality, an HD quality video of the evidence that the prosecution was using. If you notice, there is a massive difference in the quality of these two videos. One is sharper, one is more detailed, one is more fuzzy, one is less detailed. And the prosecution used the higher quality to try and change the opinion of the jury. But they provided the low quality and denied the existence of a higher quality version that was used. Now you may say to yourself, well, Mike, what's the difference? They both had the same video. Well, that's not entirely true. And let me show you what I mean. If we are looking at the video, and I want you to see this, can you make out anything in this video? Let's take a look at this video. I want to show you from the very beginning. Can you identify anything in this video? Can you identify people? Can you see what is going on? Because I don't think you can. And if you notice, those little blobs right there, that's supposed to be Kyle Rittenhouse, and the person behind him was Mr. Rosenbaum, who was theoretically, who was killed by Kyle Rittenhouse based on self-defense. If we look at what the evidence was that was being used by the prosecution, and I will show you, there is a far greater clarity that we see here. People are more identifiable, and they are not just mere blobs. And it was this higher resolution that was used to try and identify what happened that night, according to the prosecution. Now you may say, well, this doesn't make a lot of difference. But let's be clear. There is a difference. Whether you say it's a lot or a little, it doesn't matter. There is a difference. And by law, the prosecution must provide the defense the higher resolution that they had, and they chose not to do so. And we know that they chose not to do so because that is now out and part of the evidence. We have seen a testimony that has come, and it has been reported not in the United States, not by the United States News, but by the British Daily Mail, that identified that there is a motion for a mistrial with prejudice. And part of that is the violations of the Brady Rule, which you see here, and the link will be in the description for you to see for yourself. And very simply, what this essentially means is that the evidence that the prosecution has must be provided to the defense. If it is important to the prosecution, it is important to the defense, and they must provide that information as decided by the Supreme Court in 1963. That is a fact, and it is something that the prosecutors in this case are well aware of. And thus, it was something that was included in the information in the motion for mistrial with prejudice filed by the lawyers against the prosecution with the judge, which notes, among other things, the violations that the prosecution has repeatedly and continuously done when they have violated the Fifth Amendment, when they have violated the court, and now they have violated Brady statutes, and as a sum total, they have biased the jury, regardless of whatever decision the jury may in fact come up with, which is not even including the fact that the jury is now being influenced, they are being coerced by the threat of violence to them, their families, and their community with continued violent riots. And as they state in item 22, the state has repeatedly violated instructions from the court, acted in bad faith, as the judge himself has stated and is on video, you can see that yourself, and intentionally provided technological evidence which was different from theirs. For those reasons, the defendant respectfully requests the court find, quote, prosecutorial overreach, end quote, existed, and that overreaching was intentional, in bad faith, and thereby grant the defendant's motion for a mistrial with prejudice, which was filed on the 14th, which is Sunday, and we have now seen. Again, this information was not available in the United States. It was provided by the British news, and we are only just becoming aware of this. And all of the violations, we have only just become aware of the difference in the evidence that is being provided to the defense and the violations of the Brady regulations, the Brady Rule, to be exact. What this amounts to is a travesty of justice. And that cannot be accepted. That is something that is beyond the pale. The prosecution is so personally invested in this case that they are angry, shouting at the jury. They are angry personally about how they are being perceived on the internet in a trial where their goal, which they are duty bound, they are sworn to uphold justice, not Twitter views, not their job, not the future potential for a promotion, not monetary gain. They're there to protect justice. Justice in this case, it seems beyond obvious at this moment. If you take away the manipulation of the evidence, if you take away the violations of the Brady Rule, if you take away the violations of the Fifth Amendment, the violations of witnesses' rights and the defendant's rights, if you take those critical issues away, you are left with one thing. Justice says that Kyle Rittenhouse should never have been charged and he should be free at this time. Instead, there is a political agenda that is going on. There is pandering to the social media, to Twitter. Now you could say, well, maybe they're trying to protect Kenosha from additional riots from these communist organizations that are seeking to cause harm. Maybe there you may say, well, they're trying to prevent additional race riots like those of BLM in the summer of 2020. That's not their job. And that should not be the guiding reason. And when we are seeing a prosecutor violate law after law, statute after statute, rule after rule, just to promote their personal and political preferences, not only should this case be a mistrial with prejudice, releasing Kyle Rittenhouse immediately without the state having the right or the ability to go back and try him again. Not only should Mr. Rittenhouse sue the news media that have maligned his character and have lied about the information in this case over and over again, much in the same way they did so with Nicholas Sandmann, who did nothing wrong. Not only should we see that the prosecutors, Mr. Binger and Mr. Kraus, be disbarred, but they should also be criminally charged, as this is egregious. In the opening statements we heard from, it was the Judge Schroeder, had said that it is important for the confidence of the public in our judicial system to see a trial with a decision. That was removed from the jury. They never had that capability to make a decision based on the evidence that was presented to them, because that evidence has been manipulated, obfuscated, and the constitutional rights were violated. This was never a fair trial. This was never a real trial. This was a kangaroo court or an attempted kangaroo court by prosecutors Binger and Kraus. Perhaps you think we are wrong. Perhaps you think the evidence that has been provided, as we have shown you, that we are just learning about, that the jury has not been made, they have not been told, they are not knowledgeable of. If you think that we are incorrect, please, we do wish to see what evidence you have to refute this. If you think, and not just feel, but if you believe that the conclusions we have come to are incorrect, we wish to hear your answers. We wish to hear why we are incorrect in our conclusions. And if you think we are correct, please send a message on YouTube, social media, on email, stating this cannot stand. Send that to the ADA in Kenosha. Send that to your elected officials. Make them aware that you are paying attention and this cannot be allowed in the United States for anyone. I don't care who the defendant is. I don't care what state it may be. I don't care what the charges are. This cannot be allowed, because this isn't a step backwards in America. This is a step towards the socialist, communist regimes that we see in North Korea, that we see in Venezuela, that we see in Cuba and China. These are violations of human rights and the Constitution, and it cannot be stood for. That is our opinion. We stand by that and we defend that. But we look forward to hearing what you think.